We now turn to the second case on this morning's docket. It is case number 105420, State of Kansas v. Austin N. Jones.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm here today on behalf of Austin Jones, and I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, just to remind you, this is a Sedgwick County case involving a situation where Mr. Jones admitted shooting two persons in this case and shooting at another person. The dispute in this case is the circumstances under which that shooting took place. Even one of the state's witnesses in this case testified that one scenario was that the three men who were purported victims of this crime were surrounding my client and threatening him. The best case for the state, the best case scenario for the state is their witness, who was one of the purported victims, who admitted they went over there and instigated a incident with Mr. Jones, but then says they were just outside and inexplicably and suddenly Mr. Jones came out and started shooting. So this is sort of the dispute in the facts there. Seems to me one of the best facts supporting the state's contention is that Delatorre and Esparza were shot in the back of their head. In the situation dealing with that, my client admitted shooting them, so I don't think that's. But what we're talking about was the use of that deadly force necessary to protect himself. That's right. So the two issues in this case, the first issue in this case has to do with the passage of 3219, otherwise known as Stand Your Ground, Kansas Stand Your Ground law. And, Your Honor, once upon a time, I don't think I would have raised this issue because there was no such law. And once upon a time, this would have been a case where you gave self-defense instructions and the jury found my client guilty, and that was sort of the end of it. And so the question then is, does the passage of Stand Your Ground change that circumstance, that situation at all? For example, for purposes of appellate review. And my colleague has sort of argued that Stand Your Ground is nothing but sort of a screening procedure, that it provides for quick determination of immunity. And I don't dispute that immunity statutes, that's one of the purposes of immunity statutes, to quickly determine whether or not there's some, like in this case, immunity. But and we've talked about that. Part of the purpose is not to have, so that a person, a citizen, will not have to respond to those charges or go through a trial. So how are we accomplishing that purpose by raising the issue for the first time on appeal after the trial already occurred? Your Honor, and you said it, that's part of the purpose. And I certainly admit that's part of the purpose. I would compare it, for example, to double jeopardy. Double jeopardy, part of the purpose of double jeopardy is that I don't have to go through trial twice. And so, for example, that's why a defendant sometimes can bring up a double jeopardy claim in an interlocutory fashion. It's one of the only places, in fact, the defendant can bring up a double jeopardy claim in an interlocutory fashion.
I want to understand procedurally how you envision this statute working, because it's hard to understand where you assert your immunity from prosecution. Don't you do that as Justice Johnson said, at the outset of the case, or even prior to being charged? When do you assert this?
Under the terms of the statute, you can assert it at the time of arrest, detention in custody, or during prosecution. And during prosecution means during a trial, and I have no reason to assume it's any different than on appeal, that we're still in the prosecution of this case today. And so that's why it's our position that the legislature drafted this, it seems to me, in the broadest possible terms. And so the purpose of immunity, the part of purpose of immunity of avoiding trial, you would want to raise it earlier. But the other part of immunity is to give substantive protection to defendants, just like the double jeopardy clause. And because that substantive protection is still relevant, and is still relevant today in this prosecution, is why we're here today asserting this. That the legislature drafted this statute to give not just procedural protection, but also substantive protection to defendants. It seems to me...
No, you go ahead and then I'll ask my question.
It seems to me clear that the purpose of Stand Your Ground was to both procedurally and substantively protect persons who are acting in self-defense. That the legislature's purpose in enacting that was to encourage and protect the use of force in defense of self and others.
So is your argument that if we look to the language of the statute, we'll see language that permits the defendant to raise this for the first time on appeal?
That it applies during the criminal prosecution, and that this appeal is still part of the criminal prosecution.
I'm just trying to figure out why this isn't like every other issue that we talk about, where we say the issue has to be raised in front of the district court in order for it to be raised at the appellate court. And are you saying that the statute circumvents the preservation rule? Or are you just saying that it's just like any other issue, and so we should look at the normal preservation rules?
Both. I do think the language of the statute is pretty broad and talks about during a criminal prosecution, and to the extent that this direct appeal is part of the criminal prosecution, it seems to fall within that statute.
But
Even if I'm
Go ahead.
Even if I'm wrong about that, though, Your Honor, I think we could turn to, just like the Double Jeopardy Clause, for example, and look at the regular issues regarding preservation and the type of cases where you can reach an issue for the first time on appeal. And this certainly would be one of those.
But this would be a statutory protection. I mean, there's nothing constitutional about this.
But it's purely a legal issue. That's one of the other exceptions, right? A purely a legal issue that's determinative of the case.
How is
and
it
that's what we
purely
argued in this case.
How can it possibly be purely legal?
Immunity is a
It's got to
legal
be
issue.
driven by the facts of the circumstance.
You've said immunity issues, like qualified immunity for police officers, is a legal issue, and it's reviewed de novo by this court. When you review qualified immunity issues, when law enforcement officers are claiming immunity, you review that de novo. That's why it's a legal issue.
Is it ever too late to raise this as a defense?
I don't know. Once the completion of once the direct appeal is complete, that seems to me to be a line of finality, maybe, that after that you're doing a collateral attack. And I'm not sure a collateral attack is part of the criminal prosecution. So if I was going to draw a line, I guess that's where I would draw it.
So as I understand your argument, you today, for the first time, could come into the courtroom and say, we now claim this as a bar or a defense. Would not have appeared in the briefs, would have been no notice to opposing counsel, just would have been your coming in saying, we're still in the criminal prosecution, I can raise it at this time.
I think there might be separate issues about not briefing issues that can constitute bars to this court deciding an issue on whatever the claim is. I mean, I don't think I can come in here and say double jeopardy for the first time at an argument when I've never argued as an issue double jeopardy. I mean, I think that would be that's a different kind of procedural bar.
Don't we usually say immunity is an affirmative defense that can be waived if not raised? So why isn't there waiver if it's not raised at the trial court level?
I think it's possible. It's two answers. One, because the statute doesn't talk about waiver of it if you don't raise it at the trial court. And secondly, even if, as a general rule, it would operate as a waiver under this court's rules governing the ability to raise legal issues for the first time on appeal, I think you should be able to get to this issue. Again, I think if you're viewing this through the light of what's the legislature's purpose
Well, just look at the legislative purpose. Doesn't the statute say that a prosecutor cannot proceed or prosecute without finding that there's probable cause?
The statute says that a prosecutor can go forward even in light of evidence of
that
self-defense.
if there's probable cause, and we have a case out there that says that the probable cause determination has to include the state showing that there wasn't the self-defense contemplated by the statute, correct?
Yes.
So it seems more fundamental to me. We're talking about probable cause. We're saying that the state has the burden because of this immunity. when they are establishing probable cause to show that not only that the act was committed, this defendant committed it, but also that the immunity of self-defense did not apply. But once they get through that, why do we talk about it anymore? We went through the probable cause. We went to the jury. The jury found guilt beyond a reasonable doubt. Rejected self-defense. So why are we going back and talking about preserving a probable cause issue when that train left the station a long time ago?
Again, it's two answers to your question, and Your Honor, I have to admit, we haven't cited the case that you're talking about, and neither my colleague or I have cited that case, and so I'm a little cautious about whether I'm allowed to talk about it at this point under the court's rules. Am I allowed to answer the question?
I think we'll give you a special dispensation, counsel.
2 points on that, Your Honor. One, I've read that case a dozen times now, and I still don't really understand practically how that's going to be applied, how you apply probable cause to a negative finding. So that's one answer to that. But even if, and I assume the court understands how that applies to a negative finding, all we're saying is this court should still apply that as a separate protection for defendants under stand your ground, that decision was made by a district court if it was raised. It was not in this case, as we admitted, but it had it been raised, but that this court would apply it. And in fact, you did essentially apply it independently in that case that you're talking about, Ultreras. You looked at the record and you found, as a matter of law, that it didn't apply in that case. You did it as harmless error, sort of, because the district court had not applied the right standard that you ultimately found. But you ultimately then applied it and found it didn't apply. And that's all we're saying is that legal question of probable cause, if that's what it is, can just as well be applied here.
And how is it applied here? What are you seeking? What are you asking us to do?
Well, we're asking you to find that the evidence in this case does not show that Mr. Jones clearly acted outside of the realm of justification under self-defense. That's what the statute should be construed to mean. That
did not act out of the realm of self-defense. And then what do we do?
Did not clearly act.
Did not clear.
That
and
the
then
statute
what
should provide protection for
and
persons.
then what do we do with that if we find that? Find that he was immune from
then
prosecution?
You should find that he was immune from prosecution and order he be discharged on this.
And we would do that fact-finding here.
You would make that legal determination regarding immunity here.
And that's where I lose you, because it doesn't make any sense to me that you get to raise it on appeal if there are facts that would come into play, because they have to have the opportunity to put those facts into play. And if you haven't raised the issue at the district court level, then we're looking at a record where they didn't get a chance to put in something that might refute or might justify the prosecution under the statute. So it gets back to the first question that Justice Lukert asked. This is a fact-driven analysis, and they have to have had opportunity to present those facts.
Your Honor, I think that would be, I can really see that concern as a valid concern, particularly and this is why we raised in our brief, that self-defense, the issues regarding justification in this case, were fully raised at the trial court.
And rejected.
Rejected by a jury in this case.
Right.
And so we're asking for this court then to apply the statute and determine whether or not, as a legal matter, based on a fully fleshed out record on self-defense, whether or not Mr. Jones was immune from prosecution. And that's a legal question. This court has said immunity is a legal question. And we're asking this court to apply that to this kind of immunity too.
Can you not, if you're not acting in self-defense, can you still enjoy the immunity?
If you're not acting in self-defense?
Right. There's been a factual determination that the self-defense argument had no viability. So if you can't prevail on that argument, how would you get to embrace the immunity?
If this court legally finds that he was immune. That's the statute. The statute applies, and this court has said immunity, unless this court's going to reverse and say, from now on, immunity questions aren't de novo. We're not going to review law enforcement officers' claims of immunity de novo. We're just going to say those are fact questions. I guess this is my respectfully, I would say the court focused on the words probable cause in Stand Your Ground, and I think this court should focus on the word immunity in that statute. That we have a case law and a jurisprudence on immunity, and that this court should give some teeth to that statute.
And would your position be the same if the facts were a little different? In other words, there had not been a full resolution of the factual issues as you purport they were at the lower court? In other words, maybe an issue was raised, but really no evidence was put on about that, and then that record comes up here, and we're asked to make that determination based on that record when nobody really thought about putting on evidence about that? What do we do then?
There's no evidence of self-defense in the record below?
No one really addressed it.
So there was evidence of self-defense, but nobody asked for a self-defense instruction, or it wasn't argued. I want to make sure I'm getting your question right.
Right.
Under the statute and under the idea that it's a legal issue, to the extent that the record does support a holding that Mr. Jones or whoever that client is immune, I don't know what difference it makes as far as the argument. It's what the record supports. And the point here is there was certainly ample evidence of self-defense in this case. And because of that, I don't know that it matters. It helps in a case like this me to answer the Justice's question about, is it fair to the state in this case to be talking about this now? In the situation you're discussing, Your Honor, as long as the evidence is there, again, under the statute, to give meat to the statute, I think this court still needs to look at it and make a determination whether or not the person is immune.
In your view, what would be the latest opportunity under the statute that this issue could be raised?
I think on direct review of the conviction, direct appeal of the conviction.
And so, given your argument that we are still on appeal, and therefore we're still during the criminal prosecution, could this point be raised the day before the mandate was issued in this case by this court?
Yeah, again, Your Honor, I think there would be a difference in for example, if I don't raise an issue in the brief, because in a direct appeal, I think this court improperly focuses on this idea that we have to raise issues in our briefs in general. Now,
but that's a court rule. My understanding is you're telling that the legislature has told us in this instance that this is when this can be raised. So it may be an argument of separation of powers.
To the extent that I don't think immunity, and I'm not ready to say immunity is a jurisdictional issue, so I'm really cautious about sort of going down the road of saying, if it's a jurisdictional issue, I think I can raise it even the day before the mandate issues. I'm cautious about going that far. I think even under separation of powers, this court has the ability to make rules to talk about if you don't brief an issue, you waive it, or we're not going to consider it at least. And I don't know that the statute changes that. But clearly we should be able to raise the issue for the first time on appeal under the statute. That's all we're saying.
What about the last sentence of subparagraph A, which says, as used in this subsection, criminal prosecution includes arrest, detention, and charging or prosecution? And I understand you're suggesting that the prosecution extends to the end of the appeal, but isn't it the defendant's action that causes the appeal? Hasn't the state ended its effort at the end of trial in this case?
Well, the defendant sought review of the conviction, yes. I'm not...
Well, I'm just...
if the state doesn't want to
It's
pursue
automatic.
I mean,
this...
it's looking at I think we've covered that ground several times, so I won't.
All right.
Any further questions of counsel?
I have one on the other issue. I don't understand your assertion that the prosecutor invoked sympathy improperly.
When the prosecutor says the victim is crying out from the photographs, essentially. That, I mean, it's one thing to say, look at the photographs, you can infer certain facts from photographs. It's another thing to talk about crying out from the photograph.
I thought it was crying out the evidence or something like that. It was an awkward sentence construction, I'll grant you that, or word choice. But I don't see that they were trying to invoke sympathy for the victim. And in fact, one of the prosecutors said explicitly, you can't consider sympathy.
They did say that. That's absolutely true, Your Honor. I guess it's, I haven't thought of an example, maybe I can think of one. The idea of saying, well, I can't, you should consider the fact that the defendant remained silent. Of course, you can't consider that, but he really did remain silent. I mean, I don't think the fact that you say you can't consider that negates an improper comment if it was improper. It may mitigate it somewhat in the total analysis that the court does at the end, but to the extent that the crying out language itself, the purpose of that kind of sort of emotionally laden language, I think, is an appeal to sympathy. And so the fact that these go, but you can't consider sympathy, it doesn't negate that. It may mitigate it.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, Assistant District Attorney Boyd Ishwood on behalf of the state of Kansas. And before we get going too much, I'd like to clear up the record a little bit, I think. I attempted, at least to my knowledge, to file a 609 on Alteras. I think that might be what counsel was talking about. I hope everyone received it. So to the extent that was the case that counsel was talking about, I assume he didn't receive it at this point, but I tried. Did all I thought I could do. Anyway, I guess this is another one of those issues that I'm just not smart enough to figure out because the way I see it, we've already got a jury determination beyond a reasonable doubt that there was no self-defense. I don't think whatever it was that the legislature had in mind when the Stand Your Ground was drafted, it certainly wasn't to relitigate the conviction after the conviction, especially in a situation where you've never even raised it. For counsel to suggest that by asserting self-defense you've raised immunity would be to undo what I think this court, the foundation, I think, almost in Alteras, which was there's a difference between the immunity and the self-defense statute. There's supposed to be a difference. That's why we have to do something else to refute the immunity statute before we can proceed. Counsel wants to equate the two as the same, indicating because he's raised one, he's raised the other. It may work the other way around, I don't know, but by asserting self-defense at trial, you certainly haven't asserted immunity. It also struck me as interesting that counsel is free to concede that if he doesn't brief the issue, then the court can't reach it. But it would seem that similar rule would hold true if you don't assert it at the district court. I think, in fact, we cited a statute to the court that indicates that if you don't take issue with the commencement of prosecution, you've waived whatever problem it is that you can concoct that you think should have prohibited the commencement of prosecution. So I don't really know to what extent I can further this argument at all. Obviously, our position is we think that the issue has been waived. So
you'd make a distinction between raising a defense like qualified immunity, which you have to raise it. The fact that it's a legal issue doesn't mean that you can raise the issue on appeal.
Well, I guess, sometimes I have a difficulty deciphering which is a legal issue and which is a factual issue, but this certainly, if you can classify it as a legal issue, is heavily dependent upon the facts that are established. And I think maybe it was Chief Justice Nuss indicated, what are we going to do in a situation where even self-defense isn't asserted below? How are we going to deal with that? And I think that is another reason to indicate why you have to take care of this at the district court level.
Well, I guess what I'm saying is qualified immunity, which is, I think, the analogy that we were being given, is a defense that has to be raised in the trial court. It's not an issue. I don't think you can say if you don't raise a defense that suddenly it becomes an issue on appeal. That then that's the line of cases I think Mr. Hodgkinson is using to suggest that because it's a legal issue and can be decided by the court. But those are two different things, raising a defense in the trial court and raising an issue on appeal that you haven't preserved, if that makes sense.
I agree.
We may be splitting hairs on the words we're using, but it seems to me, rather than the way you're arguing, it's not a waiver that you're talking about, it's a resolution. That the immunity has already been rejected by the jury because you can't have immunity unless you fit within one of those 3 self-defense statutes that's specifically cited in the immunity, and that self-defense requires both the objective and subjective prongs, etc. And once that's been rejected, then you're not talking about probable cause. You're not talking about potential. It's been rejected.
I'm good with that, Your Honor.
I'm just curious, in terms of your experience, have you handled a 21-32-19 immunity question in Sedgwick County? Has it ever come up in trial court, as far as you know?
Of course, it would be outside of the record, but it's my understanding that on at least one occasion it has come up.
I'm just curious, procedurally, how is that dealt with?
I think it was before. It may have been before the first appearance. I'm sorry.
So it's raised prior to even charging sometimes, or I'm just curious how this plays out.
I can't recall with any level of specificity. However, I have had a question about it. This is the first case that I've been involved in that raises the issue.
Okay.
At a minimum, you think it'd come up at preliminary hearing and motion to dismiss.
I would think, yeah.
Okay.
I think that's the most I can say.
But you're not aware of how you've dealt with it at that level? Okay.
Not necessarily, Your Honor. I'd like to move on to the other issues if I could, unless there are any questions. Justice Bauer, I think that's the question about the misconduct claim with, or the prosecutorial error claim with respect to sympathy. And I think even Mr. Hodgkinson's comments, I think, kind of further my argument, which is it's not that a word is said, it's how it's used. And I think when you don't divorce this from its context, and you go back and look at how the prosecutor used this information, maybe a better word could have been chosen. How did he use it? Well, he used it to demonstrate that the physical evidence, and unfortunately in this case, it was at least one of the bodies, I think he was specifically keying it to, indicated that the defendant's position of self-defense would not be true. So I think it's the use. I think we need to focus on the use. Counsel has not raised any of the other issues.
Can I, along that line, when you're looking at context, is it fair to take the comment about the time required to pull a trigger with a 5-pound pull as intimating that premeditation can occur during that time frame?
Your Honor, I don't think so, and that's why, not unfortunately that we go to the CLEs, but we go to the CLEs and they tell you not to put the block quotes in, things like that, and unfortunately I feel compelled to do that in these situations. That particular complaint is like 15 paragraphs into what the prosecutor is describing as let's look to decide where the premeditation is, and I think at that point what the prosecutor is saying, they start with the beginning and run your way through, and they're not asking the jury to look at what time premeditation is formed, but by that time has premeditation been formed. And I think that's the distinction, and they're running through the whole, was it formed by the time they had the initial confrontation? Was it formed by this time? Running your way all the way down.
Every step.
Well, excuse me, can I follow up on that?
Absolutely.
I understand your argument, but what, if we're looking at the whole context, what does 5-pound trigger add to that? If it was formed by the time that the trigger was pulled, why does it matter how many pounds of pressure is required? I mean, it's a little difficult for me to see that was added in there without intimating that the time it takes to exert 5 pounds of pressure is contemplating or premeditating.
Your Honor, obviously I didn't try the case. I don't
Right.
know what however, I think it's just it's a matter of accuracy. It was an apartment, it wasn't a home. It was an apartment, it wasn't a trailer. This trigger may have been a 5-pound pressure. I don't know what the greater purpose was there.
The other difficulty we always confront is that the way paragraphs are set up in a transcript, for example, is arbitrary. There could have been a pause that's significant, et cetera, in the delivery of the statements that would favor one side or the other. It's really hard to see that.
Yeah, and I think that's why, at least I've found, in my mind, it's helpful to set it out this way, underline the portion that's complained about within the greater context. I hope it's helpful.
I think that advocacy trumps style in brief writing.
Can be. Unless the court has any questions about the other allegations.
I do. The third complaint was that the prosecutors told the jury that they all had to agree that there was no premeditation before they could consider the lesser included of voluntary. Now, you don't believe that's the law, do you?
Well, Your Honor, to specifically answer the question, I think that comes close to being a misstatement. However, since we're talking about a misconduct claim, I think that we need to look at it in the context of the argument as a whole and the instructions given to the jury. And this would be the last comment, I think, that was made on it. The first issue was instruction to the jury. That was accurate. I don't think anyone claims it wasn't. And the second point that I'd like to make is that the prosecutor before that did say, if you cannot agree, talking about the same concept. So this isn't, again, we're isolating one comment and not looking at its greater sense. But this particular comment, I think, comes close to getting it wrong.
If you cannot agree, intimates that you all are on the same page, which intimates that that there's no one that doesn't believe that there's premeditation. And I just can see the scenario where the foreman says, no, we can't talk about voluntary manslaughter because some of us believe that there was premeditation. There's one person who believes there's premeditation, so the prosecutor says we can't talk about voluntary manslaughter.
Well, I think that's the fear, obviously, but the instruction, as I recall, it says if you do not agree. The first comment by the prosecutor is if you cannot agree. I don't know, and that's why it would be helpful. And obviously, we've stepped back from for years now. We've stepped back, but I'll keep putting it in the brief. It would be helpful if we could have an objection so we could clarify what the point is. And if we don't have that objection, I think that there's a couple people in the room that's supposed to be looking out for the defendant. One is his counsel, and the other, for fairness, is the judge. And nobody in the room jumps on this, and yet now all of a sudden we're going to pretend as though the jury is like, wow, now hold on. There's a difference between cannot and do not. And
I think the difference between the two statements here, the first one, to my mind, not being problematic because it does mirror the instruction. If you cannot agree on the first charge, then you move to the second charge. But the second time is you all have to agree. I mean, it suggests that you all have to agree there was no premeditation before you move on, and that's the problem. It's the all part.
And thank goodness that we've got the ill will and the gross and flagrant and that type of an inquiry that we need to make. And I think you'd be hard pressed to establish or come to that conclusion based on this record.
That it changed the result,
or even that it was purposely done. I think that if you ask me right now, I'd probably say it wrong, even though I know which way is accurate. Unless the court has any questions on any of the other issues, we'd respectfully request that the decision be affirmed.
Any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
My only comment is, as Mr. Sherwood was talking, and I was thinking about this immunity, and it's one thing, and since this is sort of a case of first impression in some ways, or second impression, it will be one thing if the court says the record in this case is insufficient, or we deem that the issue has not been fleshed out enough to review this for the first time on appeal, and because it wasn't raised below, we're not reaching it now. That's an application of this court's law, I guess. It's another thing, though, to adopt the state's idea here that if you don't raise this at the proper time, and by allowing this to go to trial, you have given up the protection of that statute. That's another issue. And just as I was thinking about, Your Honor, if that's right, if Mr. Isher was right about that, then I guess these cases will start falling into the class of cases like double jeopardy, where we're going to have, I guess, interlocutory appeals by defendants after preliminary hearings, because otherwise the defendant will never be able to bring that claim of immunity to the appellate court. If he's right, that by allowing the case to go to trial, you have waived or forever given up your immunity.
By allowing it to go to trial with no objection, is what you're saying.
Well, if by going to trial you waive, it's a separate issue, I think, procedurally, if you say you can't raise it on appeal because you didn't raise it below. That's one operation of this court's rules. It's another thing to say, if you don't raise it, you've given it up forever. Therefore, the only way to get it to the appellate court is some sort of interlocutory original action type thing, like we do in double jeopardy cases. And maybe that's probably, I think, under my interpretation and under the plain language of the statute, maybe that's appropriate, but it would be mandatory if Mr. Isherwood is correct about his interpretation of the statute, that it's only a screening function and no substantive protection.
Any further presentation, counsel?
No, Your Honor.
Any further questions of counsel?
Thank you.
Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement. At this time, the court is in recess for 15 minutes.